we have another speaker in the panel, Mr. Zubair Ali, would come to speak to us on legal and medical considerations.
Respected chairperson, keynote speakers, and my co-speakers, good afternoon to everyone. Myself, Mohammad Zubair Ali. I am here to speak about euthanasia and its legal and medical considerations. What is euthanasia? Euthanasia is a practice of intentionally ending the life of a person to alleviate his suffering or a pain. As we know about active and passive euthanasia, I am here to say about three other kinds of euthanasia, that is voluntary euthanasia. Voluntary euthanasia refers to a person is being killed by his own consent, and involuntary euthanasia, a person's willingness is not considered and he will be killed by giving euthanasia. And non-voluntary euthanasia. Non-voluntary euthanasia refers to a person, the patient is not able to give his decision on the circumstances. For example, we can take as children, and as we know, there are both positive and negative sides of a thing. So positively, euthanasia can be called as a mercy killing, but in negative manner, it is quoted as legalized murder. In India, active euthanasia is illegal and crime under section 302 and 304 of the IPC. This is illegal because we have article 21 in our constitution, that is right to life and personal liberty. As we are talking about article 21, there are many interpretations of article 21 regarding euthanasia by judiciary. In Bombay High Court, it gave an interpretation that right to life and personal liberty of an individual includes right to die, and through this verdict, section 309 of IPC has been made as unconstitutional. Section 309 was suicide, which is illegal. So in 1996, again the Supreme Court has revoked this earlier judgment and gave that right to personal liberty doesn't include right to die. So what is the difference between suicide and euthanasia? Suicide means a person is going to be killed voluntarily by hanging or consuming intoxication of any poison, etc. But euthanasia is a situation where a third person is involved in helping them actively or passively to kill him. In 2018, Supreme Court has recognized passive euthanasia and decided that High Court is the ultimate decider of passive euthanasia. There must be a bench of minimum bench of 2 judges who should review the case of euthanasia. So there are some criteria in which a passive euthanasia should be administered to a person. Firstly, we have permanent vegetative state. So a person need to be in a permanent vegetative state where his disease or his treatment is irreversible or incurable. And 2 doctors, medical certification should be required by 2 doctors who will be checking the vegetative state of a person. And later, district magistrate board must approve the condition of his vegetative state. And there must be a family consideration because they are the only ultimate caretakers of the patient. And in last, patient willingness is must and should, because he is the only sufferer to uphold a willingness of a patient. The Supreme Court has gave another judgment that there is a living will. Living will refers to a document where a person or a patient writes in his own in his normal state of mind, seeking passive euthanasia if he or she reaches a permanent vegetative state. This document is considered as a decision of patient by doctors in further treatment. Though we have these stringent laws, we have many challenges which should be considered. Some argue that the process in which the euthanasia is administered is very complicated. Some other also we have also other concerns such as misuse of euthanasia. Misuse, as our co-speaker said, that misuse of euthanasia regarding voluntary weaker sections of society, economically weaker sections, or some of them such as some other sections, and we have the pressure on the family taking tough decisions. So at last I would like to conclude that morally euthanasia is not correct, but ethically there are some considerations need to be taken on from a patient because he is the ultimate sufferer. Thank you.